Hey y'all, thanks for tuning in. I said I'm gonna take a break from the Blood Money series, and I'm gonna just do a couple short videos for some newbies. I'm gonna do a Misconceptions quick series. That's what today's gonna be, and then the next one's gonna be just a bunch of articles on the assemblies and how the state assemblies work and what the state assemblies are. Because I know, I remember how it was when I first heard about this and when I first started learning about it. It's exciting, it's new, and it's confusing because we're so indoctrinated and brainwashed on so many levels, and we're so used to the corporate structure of compartmentalization, where you only find where you get orders and you only get a little piece of information or a couple of duties, and that's all that applies to you. But in the real world, in the world of self-governance and of the real American government, it really is of, for, and by the people. So not only do we each have to self-govern in the respect of being aware of what's going on, but we also have to self-govern when it comes to research, when it comes to organizing, when it comes to taking care of our own affairs, and that's what self-governance is. But when you take care of your own affairs, you have options, right? You decide for yourself. When you're an American and you're standing on the land and soil, once you've reclaimed your good names and your estates and your proper birthright political status, remember you have all your unalienable rights intact. You have all your constitutional protections and guarantees. So think about how many statutes, rules, regulations, codes, policies, and procedures just don't apply to us. And throughout most of our lives, we've been indoctrinated and you know, just accustomed to just going along with that, and we thought that that was the only option. We thought that we had to do this, and we needed to do this. So when we find out that not only are we not, either supposed to, or not only do we not need to, it's actually unlawful to do a lot of these things. So as you start to walk, in your proper status, and as you start to learn more truths, and as you start to break the shackles, and you start to connect more dots, and you start to research more, it'll all start to make sense, very quickly. And once it becomes, it's just like anything else, just like a song or a book or a story. Once you hear it a few times, you know it. So let's get it started. We're going to do misconceptions. Misconceptions, common misconceptions 1, treaties versus constitutions. So I am constantly running into misconceptions people have adopted through suppositions and assumptions made in ignorance, which isn't a bad word. That just means that, information has been ignored, right? And those wrong-headed ideas grow into a life of their own when shared. So let's prune out that static. First and foremost among these wrong assumptions is the idea that the constitutions are the supreme law in international affairs. They're not. Treaties outrank constitutions. Constitutions must conform to treaties, not the other way around. The constitutions we have are typical of constitutions everywhere. They are power-sharing agreements with business organizations that implement treaties and which, I'm just going to read that again. They are power-sharing agreements with business organizations that implement treaties and which result in debts and performance obligations on all sides. Look up the legal definition of the word constitution, and you will learn that all constitutions are debt agreements. Our constitutions define and hire 3 federal subcontractors. 1, the American Federal Republic. 1 British territorial organization, and 1 Holy Roman Empire municipal organization. The states are obligated to pay in gold and silver for their services that each of these subcontractors perform, and they also agree to delegate certain enumerated powers to these subcontractors to enable them to provide the related services to be performed. There is nothing mysterious about this and nothing sacrosanct. The constitutions are called the law of the land because all federal subcontractors operate in jurisdictions other than the land. They operate in the international jurisdiction of the sea or in the global jurisdiction of the air, so that when they come ashore, the constitutions lay down their limits and their duties. It's the law of the land from their perspective, not ours. The constitutions do not represent the full scope of our land law. They merely represent the land law, and the federal subcontractors are obligated to follow with respect to us and our states of the Union. The federal subcontractors were all business organizations and functioned initially as unincorporated businesses. Following the Civil War, the American federal subcontractor, doing business as the States of America, was no longer operating because the Confederation sponsored and directed it, and the Confederation itself ceased functioning in 1860. The reconstruction of the Confederation was never finished, and the fate of both the Confederation and the Federal Republic, our American federal subcontractor, both were held in abeyance. It means inter regnum, until they meet again. It's just in limbo, waiting for the states to assemble and complete the reconstruction process. We have been in abeyance, waiting 160 years. This is the first time that the States of the Union has assembled since the Civil War. Misconceptions 2. Your urgent attention, please. So the two remaining foreign federal subcontractors, from the two other federal constitutions, are the British territorial government and the Papist municipal government, incorporated their business interests following the Civil War. And there was no rule prohibiting them from reconstructing in this way, despite all the confusion about the Act of 1871 and the Municipal Acts. As businesses, all three federal subcontractors had offices of a president associated with them. Look up the legal meaning of president, and you will see that this is merely the CEO of a business. The presidential office associated with the American federal subcontractor, doing business as the States of America, was, uppercase, lowercase, the office of the President of the United States of America. The British territorial office was and is the office of the President of the United States of America. So you see in this one, with the British territorial, the United, the U is capitalized. And in the States of America, united just means they're united. It's an adjective. So that's the difference. And y'all will see when you open it. The Papist municipal office was and is the office of the President of the United States, of America. Successive corporations sponsored by these foreign federal subcontractors doing business generally as the U.S. Inc. and the USA Inc. have undergone cyclical and deliberate bankruptcies. These bankruptcies has been used to offload the corporate debts of these foreign federal subcontractors onto the backs of unsuspecting Americans who were unknowingly left standing as sureties for the operating expenses of these corporations. And let's put it this way. Left to themselves to interpret their duties and the meaning of their contracts, these foreign federal subcontractors, the British territorial and the municipal Papist, have mightily helped themselves to our labor and our assets under conditions of non-disclosure and fraud. The abuses and usurpations have gone so far as to presume that we left and went somewhere over the seas and abandoned our country and our assets, leaving everything to be divided upon and among our erstwhile employees and their creditors. This is the bunco setup we are facing off right now, and every American loyal to this country needs to show up for duty. Number 3, misconceptions are organic laws. There are only 4 organic laws underpinning this country and every American. Had better believe it. Study each one and understand the setup. The first organic law, the unanimous Declaration of Independence. There were other declarations before and after, pertaining to the territorial United Colonies, etc. But the one that pertains to us, Americans, is the Unanimous Declaration, published 4 July 1776. This stated the War of Independence, also known as the Revolutionary War. Started it, I'm sorry. The second organic law is the Articles of Confederation. In so much as humanly possible, the Articles of Confederation established a perpetual union among the member American states of states as of 1st of March 1781. Please note that this was done in the midst of the Revolution, and 5 years after the establishment of the Federation of States, doing business as the United States of America. The third organic law is the Constitution, whichever one applies to you. Is it the Federal Constitution, which is, remember, the States of America? Is it the Territorial Constitution, or is it the Municipal Constitution? We have been thought to think of in terms of there being only one constitution, but there are in fact three, and three different groups of people with one constitution each. So the American Constitution, 1787, the Territorial Constitution, 1789, and the Municipal Constitution, 1790. The fourth organic law is the Northwest Ordinance, which establishes an orderly process for new states to be organized and to join the Union of States. As each new piece of wilderness was populated, it was placed under the control of the territorial government and existed first as a territory, then entered territorial statehood, and finally was accepted and enrolled as a full state of the Union. Everyone who ever saw an old John Wayne Horse Soldier movie has had a taste of this process. Who was out there on the Great Plains? The U.S. Army Cavalry, that is, the territorial government acting under martial law. And who else? The U.S. Marshals. Prior to the Civil War, states like Ohio and Wisconsin and Illinois went through the same process, existing first as territories, then entering to territorial statehood, and finally being enrolled as states of the Union, having equal footing with all the other states. During and after the Civil War, many more states got organized and populated, and went through the process ordained by the Northwest Ordinance. They became territories, then entered territorial statehood, and then, nothing more. The states were not in session, so there was no government operating the land and soil jurisdiction, and no way to complete the process and enroll these later states as states of the Union, until now. Remember, the states of the Union have not been in session for 160 years. Nobody was home to welcome the new states into the Union and finish the enrollment process. So these, mostly Western states, remained in limbo, in a quasi-territorial status, endlessly waiting to be enrolled as actual states of the Union, according to the Northwest Ordinance process. The actual properly declared state assemblies are now in session. They were polled for a roll call vote this September, and the Western states were finally and officially enrolled as states of the Union, having the full rights and prerogatives of every other state, beginning at midnight of 30th September 2020, and retroactive to the date that each state entered territorial statehood. And all those Americans who were arbitrarily misidentified as territorial dependents and who were born on the land and soil of these mostly Western states are now also due a complete status correction and recognition of their standing as American state nationals, right, and American state citizens. Misconceptions 4, land and soil. Ever notice that ubiquitous phrase, land and soil? Ever wonder why they don't just lump it together under one word, like dirt? The Romans, and later the British, made a distinction between land and soil and the Americans followed suit. Under Roman civil law, the soil, soli, comprises the first shovelful of dirt overlaying all the rest, which is the land. The British Convention defines soil as the top 6 inches of the earth, a sort of intransigent, permanent skin that covers the entire planet, including the ocean basins. The Romans assessed their empire according to a system of distances and landmarks called stadia. The Brits adopted this system and measured their roads with mileposts and their farm fields with acres, measured via horizontal Cartesian coordinates and marked with boundary stones. So the defining measure of soil is depth, and the defining measure of land is horizontal distance. In the system which we inherited, the two things, land and soil, are actually quite different, even though they must be considered together because the soil overlays the land. As a practical matter, we all live on the soil. In America, our countries define our soil jurisdiction. And the counties within the borders of a state, taken together, create the soil jurisdiction of each state. So in Georgia's case, not the state of Georgia, in Georgia's case, all 161 counties make up the soil jurisdiction. The soil jurisdiction within each state borders comprises its national jurisdiction. So Georgia's national jurisdiction is all the counties. If you similarly join all the different state soil jurisdictions together, you find yourself looking at the United States, unincorporated, the familiar multicolored political map showing our states as 50 pieces connected to each other like a crazy quilt. So 50 national jurisdictions make up the international land jurisdiction. Directly underlying this quilt top of soil is the land, right? Made up of the subsoil and all the minerals and rocks and hidden aquifers and oil deposits we access when we drill wells. If you were to map out the land directly underlying and belonging to each state, you would have another crazy quilt. But this time, you would be looking at the United States of America. Land, unlike soil, is an international jurisdiction. So all the national jurisdictions, internationally, right? Doing business together. Land, unlike soil, is an international jurisdiction. Think of it like a layered sheet cake, with the soil layer overlying the land layer, and the whole thing cut up into state pieces. Also think of it as the United States overlying the United States of America, whose reach extends beyond the shores of our nation's states to the edge of our currently claimed international sea boundary. That is, a proper map of the United States of America would not only show the land jurisdiction of the states, but would extend out into the sea and include the maritime borders, defined as American waters. Thus, the national boundaries of our states and of the United States are fixed and immutable as a depth dimension, but the international jurisdiction of the land and sea overseen by the United States of America is quite subject to change, as proven by over 200 years of disputes over everything from deep-sea fishing rights to ownership of oil reserves in the Arctic Ocean. Misconceptions 5, we the people. The meaning of the phrase, we the people, seems self-evident, but it's not. There is a reason why the founders used a capital P. By separating the national soil jurisdiction from the international jurisdiction of the land and sea, we wound up with two names for this country, both the United States, national soil jurisdiction, and the United States of America, international land and sea jurisdiction. And knowing this, you are finally ready to take in the difference between people, lowercase p, and people, capital P. The people of this country live in the United States, meaning all the counties, and stand on its soil. But the capital P people, with a capital P, inhabit the United States of America's international land jurisdiction and stand on the land. The people, capital P, are the only ones who can enforce the law of the land, that is, the constitutions, because they are the only ones occupying the international land jurisdiction of this country. And they are the only ones who ratified the constitutions. When we act as state citizens, we are not only counted as one of the people of this country, capital P, we are also recognizable internationally as lawful persons. We made a video on that, right? Lawful persons stand on and occupy the international land jurisdiction of every country on earth. Together, we uphold the public laws of our land jurisdiction, including the constitutions, and we accept our public duty to do so. Legal persons, by contrast, occupy the international sea jurisdiction, a watery domain full of deceits. Legal persons function under private law, codes, regulations, statutes. The officers and employees of all incorporated businesses are all acting as legal persons by definition. Thus, we have people living in the United States, lowercase p, right, the counties, and capital P, people, occupying the land jurisdiction of the international United States of America as lawful persons or state citizens. And we have legal persons occupying the maritime jurisdictions belonging to the United States of America too. The hard part arises when you can't tell the difference between the people, lowercase p, the people, capital P, and the legal persons. In the last few decades, the number of us consciously functioning as lawful persons has greatly declined, and the number of us unconsciously functioning as legal persons has increased. What this means in practical terms is that there are fewer and fewer of us who are declared and competent to enforce the constitutions and other public laws, and more of the people living in the United States are being illegally and immorally conscripted into foreign political status of legal persons, known as U.S. citizens, who have no constitutional guarantees, no standing to enforce the constitutions, and no ability to defend themselves from rapacious foreign courts and tax collectors. We need a few good people, lawful persons, to put the teeth back into the constitutions. The fast track belongs to those who are not employed by incorporated entities and not receiving any unearned welfare benefits. Misconception 6, the states. You can have a state of mind, you can have a state of state, and you can have a state of state, all capitals, and a state of grace. You can have a federal state, and you can have a confederate state, and you can have a natural state, and emotional states, and inchoate states, and dependent states, and sovereign states, and territorial states, and, well, you get the idea. We can go on for half a page or so, just to scrape the barrel, but obviously the word state is not one you can take for granted. In the actual factual place called America, when we say state, we mean a physical state defined by political borders. These states are governed by the state assembly, population, living within the borders of each state. So these physical states, these actual states, America, the states of the Union, are governed by the state assembly population living within the borders of each state. So the Georgia Assembly governs Georgia. The Virginia Assembly governs Virginia, and so on. These states all function in a dual capacity. First, as a nation state, in control of the soil jurisdiction, and as a member state of the United States. And second, as a state of the Union, functioning in international jurisdiction, and acting as a member of the unincorporated federation, doing business as the United States of America. Now take in the key words: physical, borders, state assembly, population, nation state, soil jurisdiction. Uppercase, lowercase, the United States, State of the Union, international jurisdiction, federation, uppercase, lowercase, the United States of America. We are talking about actual places and actual people, and associating them with the imaginary borders and jurisdictions and organizations. It's what we call a hybrid reality, where we attempt to organize and govern what is actual and factual via a series of thought constructs. The first such thought construct is provided by the political borders that define a state, and then all the political borders that define counties or parishes or townships, etc., as political subunits within each state are added. This provides a framework that we use to establish and organize local government authority over land and soil resources, including the people who live on the land and soil. The second thought construct is the definition of the eligible population comprising the state assembly to govern each state. Each state has a population of people, remember, the county, lowercase people, and the lawful persons, the international people, who live within its borders on a permanent basis and who take part in the local county assembly or state assembly, or both. The third thought construct is the definition of the jurisdictions: air, land, sea, and soil. As a practical matter, land and soil are often clumped together. Surface water belongs to the soil jurisdiction, unless we are talking about navigable inland waterways, large freshwater rivers, like the Mississippi River. Merge with and become part of the sea jurisdiction. Underground water aquifers belong to the land jurisdiction. And the air is everything impermanent above the surface of the soil, including water vapor and radio frequency radiation, smog, fog, jet streams, flight corridors, Wi-Fi, electricity, and flights of fancy. I'm just going to reread that. The third thought construct is the definition of the jurisdictions: air, land, sea, and soil. As a practical matter, land and soil are often clumped together. Surface water belongs to the soil jurisdiction, unless we are talking about navigable inland waterways. Large freshwater rivers like the Mississippi River merge with and become part of the sea jurisdiction. Underground water aquifers belong to the land jurisdiction. And air is everything impermanent above the surface of the soil, including water vapor and radio frequency radiation, smog, fog, jet streams, flight corridors, Wi-Fi, electricity, and flights of fancy. The air jurisdiction is the realm of thought, where all these thought constructs come from in the first place, and therefore also the realm of logos, trademarks, patents, and copyrights, and logos. The fourth thought construct we've encountered is another layer of reality, removed from the level of the rocks and trees, organizations that form as a result of the political subdivisions and thought frameworks we've created for our convenience thus far. The states, as represented by their state assemblies, join the international land jurisdictions together as members of the United States of America, and join their national soil jurisdictions together as the members of the United States, which is also called the Union. Thus far, we have only considered what we mean in the international American government, in the traditional American government, when we say state. There is another kind of state that comes into play in our American government. Each state has a state-of-state organization associated with it, and these state-of-state organizations are called Confederate States. All of them, both North and South. Please note this can cause a lot of confusion because both the actual state and its Confederate state can be called a state, when in fact they are very different entities and are of different natures and have different levels of authority. By their nature, state assemblies are called into session when necessary, because the population of each state is busy living life and pursuing jobs outside of government. The state-of-state organizations, by contrast, are paid to provide the routine services that the state assemblies approve of on a year-round basis. These are the bureaucrats and offices that we are familiar with, and which many people confuse with the actual state. The state-of-state organizations are actually our employees. They are borrowing delegated authority from our state, operating under the guidance of their state-of-state legislature. And their primary function is to engage in international trade and asset management, and to provide routine government services approved by the state assembly. Please note, you have a state and you have a state-of-state, both. Your state is a member of the United States of America, which is a federation of similar states of the Union, unincorporated. Talking about Georgia, Virginia, Florida. Your state-of-state is supposed to be a member of the States of America, which is a confederation of such business organizations. We will get to the supposed to be later. Thus, we have the soil jurisdiction nation-states forming the United States, also known as the Union. That's the national soil jurisdiction. We have international jurisdiction states that are members of the United States of America, our unincorporated federation. We have international sea jurisdiction states of states that are supposed to be business members of the States of America Confederation, operating under delegated powers of the states. And finally, we have global commercial states of states, which is the global air. If you take your thought constructs one step further away from the actual and factual world, you land in the air jurisdiction, in the airy-fairy world of global commerce. Although it isn't necessary, you can also have a state-of-state organization, which is incorporated for the specific purpose of taking part in global commerce. All capital letters, right? Commerce is defined as business between two incorporated entities. Commercial state-of-state organizations are chartered and guaranteed by sovereign governments, but not necessarily your own. To summarize, number one, the United States, uppercase, lowercase, is the soil jurisdiction, which is the county assemblies, which is our local government, which is a private local business of, for, and by the people, right? The nationals and citizens at the county level. Number two, the United States of America, uppercase, lowercase, land and sea jurisdiction, state assemblies, interstate and international business. This is the lawful persons. And you have number three, the States of America, our missing confederation, delegated sea jurisdiction, state-of-state legislature, government services, interstate and international business. And you have number four, states of states, all capital, right? Commercial, operating in global commerce, have to be chartered and guaranteed by a sovereign government, but not necessarily our sovereign state government. Misconception 7, lawful fictions and legal fictions. In our discussion about states, we got a glimpse of how many different kinds of states there are, or which may be defined and labeled, and thus come into a kind of existence that we accept as being real, much as we suspend our sense of reality when watching a movie. When we describe our states of the Union as physical places with political boundaries, most of us realize that the political boundaries are fictional and more or less arbitrary. These political borders exist by social convention, a sort of mutual group acceptance that agrees to honor the existence of the border between, say, Wisconsin and Minnesota, Georgia and Florida, New York and Pennsylvania. Even though we know that there is no such border mandated by nature and no fence separating Hudson, Wisconsin from St. Croix, Minnesota. We call these mental construct legal fictions. And yes, Hudson, Wisconsin, and St. Croix, Minnesota are legal fictions too. They don't really exist, but we name a spot on the globe, give it a label, and voila, a mixed reality is born. The actual place is wedded into an artificially constructed location and an arbitrary label, resulting in St. Croix, Minnesota, or Detroit, Michigan. It's handy as can be. If you need to get to Detroit, or want to tax property located in and around St. Croix, Minnesota. But we need to realize that this is all fictional and arbitrary, a sort of matrix or grid superimposed on the factual world we actually live in. Yes, there is a town built at the location we call St. Croix, Minnesota, but the town isn't the location, and the name isn't arbitrary. We could just as well call that location Lumsdale, Umsaqua, but once you became aware of legal fictions, you can see them everywhere. The title or patent to a piece of land is a legal fiction. I'm going to read that again. Once you become aware of legal fictions, you can see them everywhere. The title or patent to a piece of land is a legal fiction. The name of your bank is a legal fiction. Even your proper name can be unlawfully converted and construed as a legal fiction. While we all know that GM, BMW, and IBM are big commercial corporations in various lines of business, it's generally harder for people to see that DOJ, FBI, CIA, USMC, or U.S. District Court, State of Georgia, and IRS are also all commercial corporations in various lines of business in exactly the same way. The Department of the Army and the Akanto Fire Department and the Green Hills Food Cooperative are all legal fictions too. These organizations, which appear to be part of the government, aren't part of any sovereign government at all. They are subcontractors, hired professionals who are employees of corporations that are, in turn, subcontractors of various incorporated holding companies, who are, in turn, subcontractors of principals who are obligated to perform under the constitutions. More legal fictions. With every layer or compartment built within the system, both knowledge and accountability are lost, until we have subcontractors of subcontractors of subcontractors of subcontractors. And often, the end-line subcontractors are being misguided and are ramming around, terrorizing the people who fund their paychecks. This is what happens when we let legal fictions run wild and fail to recognize the difference between all these persons and living people. Or even worse, forget who we are and where we are. We can lose our way and become lost in a fictional world, at the mercy of the monsters who inhabit the realms of fiction. Thought forms, or as we call them, thought constructs, are very handy for organizing things, for making useful plans and agreements, and for defining functions and duties. Thus, especially in terms of business and government, thought constructs and legal persons are common as dirt, and most of us can readily understand that mayor or governor or any such office of personhood is a legal fiction as well. Both private corporate offices and public offices are all legal fictions. Each such legal fiction has to be defined, and a label or title has to be applied to it in order to give it form and certain meaning, just as GM had to define itself with a name and trademarks and copyrights in order to distinguish its products and business persona. Each office has to have duties and rights assigned. One of the pernicious evils of using legal fictions as we use them today is that the lines between fact and fiction often can become blurred, and our awareness of legal fictions can become dulled to a point where we no longer realize that we are dealing with fictional entities like the state of Georgia or the state of Florida or any of them. When this happens, the meaning and importance and standing of actual and factual people can fade away and be lost in the hall of mirrors. Let's take an important example, our name. Let's say that your parents named you Ellie Mae, which is your given name. And also say that you are inherited the family name Johansson. Your proper name is then bicameral. It has two parts, or houses. Ellie Mae is your house, and Johansson is your family house. We see this same system in play in legislatures, congresses, and parliaments throughout the world. Taken together, this yields your proper name, Ellie Mae Johansson. Your proper name is called your lawful person. It's a person, that is, it is a fiction, but it is lawful, and therein lies an important distinction. Lawful persons stand under and are protected by the public law, such as the constitutions. Legal persons stand under various names and forms of private corporation law and have no such protections. And here's the rub. In international jurisdiction, there's no practical way of telling the difference between your lawful person standing on the land and a legal person of the exact same name employed by a corporation. Ellie Mae Johansson looks and sounds the same whether she is standing on the land or drifting on the sea. But bear in mind that the lawful person known as Ellie Mae Johansson is owed to public law and all her constitutional protections, while a legal person, also named Ellie Mae Johansson, is subject to whatever whims and private laws and statutes and codes her bosses dream up for her. Your given name, in this case Ellie Mae, is your own property, a gift from your parents. Your family name, in this case Johansson, belongs to all the Johanssons that are scattered across the world. Your proper name, also known as your lawful person, in this case Ellie Mae Johansson, stands on the land of your birth and under the public law, including the constitutions of your country. Your proper name, however, can be mistaken for the name of a legal person operating in the international jurisdiction of the sea, and such legal fictions are subject to whatever abuse and whims and codes and regulations may befall them. Why? Because legal fictions are unhinged and detached from factual reality. I was recently sent an article in which the United States Bar Association, a municipal corporation franchise, voted to implement forced vaccinations and make them mandatory. But we can't prosecute them for it. It's almost a joke. You can't harm a corporation by vaccinating it. Bring on the needles. You can only harm clueless people who have forgotten who they are and who voluntarily line up and obey mandates issued to legal fiction persons like Ellie M. Johansson, just like Calvin Klein, the legal fiction, the all caps, the corporation. The tragedy is that there are plenty of clueless people who do accept such bogus mandates and who do act upon them to their own serious detriment and the detriment of others around them. When they come back to the United States Bar Association and to Pfizer and to United States government, because they are the only 1 in 25 who has been crippled, maimed, or murdered as a result of obeying such a mandate, their or their devastated families will be told, "We're sorry, but you did this to yourself. It was entirely voluntary." Voluntary. Just like paying federal income tax is voluntary. Just like selective service is voluntary. Oh, and by the way, since the 1980s, all the vaccine manufacturers have been released from any responsibility for adverse side effects caused by vaccines. The United States Congress, municipal, used to stand good for it, but they are bankrupt and permanently out of business. So take your misery and your injuries down the street, because there is nobody here who owes you any care or consideration for vaccine-related injuries. P.S. We are all legal fictions, and if you are a living man, too bad you got confused about that. Let's see if Facebook has the balls to ban this information as being contrary to their community. An example, corporate standards. Number 8, jurisdictions. You are now beginning to see the tip of the iceberg and just how complex the inner workings of what we call government and the language of government can be. Take an innocent word like state or person, and it can and does immediately morph into a monster with great multiplicity of meaning, most of which is undisclosed except by context, and some of which can't be discerned either by sight or sound. Remember and take note that Ellie Mae Johansson at sea looks and sounds exactly the same as Ellie Mae Johansson standing on dry land. But depending on where she actually is and what she is doing, she is standing under the different forms of law. On the land, generally speaking, she is standing under the public law, the law we automatically think of and which we assume is in play. At sea, she is standing under the private law, the law of ships and corporations and private business enterprises and military services. These different forms of law arise in different jurisdictions, and it is time to more fully describe what a jurisdiction is and how they arise. They arise from nature. The nature world is organized according to an observable plan that includes three realms, which we call air, land, and sea. So there are three basic jurisdictions. But notice this, there's only one jurisdiction that bumps up against and intermingles and distributes itself through all three, the realm of water, both fresh and salt water. You have the actual sea called the high seas, and you have the maritime jurisdiction, where salt and fresh water meet. And you have surface water and groundwater, and you have water vapor in the atmosphere too. Wherever and whenever the jurisdictions mix or meld or rub against each other, and that is wherever water is involved, we have problems when we use the model to organize our governmental and business affairs. The maritime jurisdiction, the tidewater and coastal interface, where the freshwater meets the sea, has always been especially problematic, and so has the merchant marine service that occupies this peculiar jurisdiction. Though we landsmen don't often think of it, pause a moment and think about the vast flotilla of ships of every nation flowing to and fro along sea lanes and carrying unmanageable tonnage of cargo to ports of every country. This is by far and has long been the largest trade and enterprise operation on earth. And maritime law is commensurately international, complex, and octopus-like nature. Because maritime trade and commerce, note that word, commerce, occupies such a command position in determining the flow of goods on the sea and the ownership of cargo being transported and all the details of maritime insurance, employment, contracts, and retirement, display of national colors, and dispensation of government on board these civilian vessels. The maritime law was extended to the land jurisdiction via the adoption of post roads that function as dry sea lanes in the 18th century to promote the safe conduct and ease of distribution of goods and cargoes on dry land. These roads and service stations associated with them are under the command of postmasters on the land and postmasters on the sea. The extension of maritime law onto the land is what Ben Franklin was engaged with when he and George Washington began surveying post roads in America, well prior to the Revolution. Please note that these post roads that connect every post office and their easements and rights of ways together actually belong to the land jurisdiction of this country and naturally fall under the direction of the land jurisdiction government. Our Federation of States doing business as the United States of America. These ownership interests and controls are exercised and organized as postal districts, administered by postal district courts, and are administered by postmasters, not postmasters. Please also note that when you step off the dock, these roads become sea lanes, and if you are suddenly in the international jurisdiction of the sea and operating under a different system of maritime law administered by the British King. The difference is that on the land, the operations of the international enterprises have to obey the public law. But on the sea, the operations of these international enterprises are private. The captain is king of his ship, and the corporation's policies are law. In the 19th century, these inroads of maritime jurisdiction onto the land were increased via the addition of railroad and utility corridors, and their easements, which also operate in international jurisdiction and maritime law. More millions of acres of our land were subsumed under the supervision of the postal districts and made subject to the international maritime law, albeit still subject to administration under the public law, including our constitutions. Most of the corruption we are seeing now is a direct result of corporations involved in doing business in these special maritime jurisdictions, running rampant and usurping upon the land jurisdiction, and undermining and disobeying public law. The Queen and her government and the Lord Mayor of London and the government of Westminster and the British Crown are particularly and especially responsible for this misadministration and usurpation and breach of trust. That said, the rest of us have a responsibility too. And that responsibility is to keep them in their briny place and to recognize and exercise our land jurisdiction and man up our lawful government in that jurisdiction, our unincorporated federation doing business as the United States of America. Our postmasters are called to duty. Our postal district courts are convened, and all the lawyers in this country are in need of a wake-up call. The King's Courts have been operating on our land and soil and enforcing seagoing maritime law on our general population, and are operating as crime syndicates in violation of their treaties, their commercial service contracts, and in violation of the constitutions that allow their presence here. Most seriously of all, they are operating in gross breach of trust. This circumstance gives rise to widespread endemic and institutionalized criminality and misapplication of law. If the bar attorneys do not wish to be considered accomplices to these crimes, they and the higher jurists acting as judges in these courts need to hike up their skirts, dust off the actual applicable law, public law, and turn tail. Otherwise, they are completely recognizable as inland pirates, and the kindest retribution reserved for inland pirates is public hanging. Other options are gibbeted and flaying. Gibbeting and flaying. This is not the first time that maritime law has usurped upon the land jurisdiction, and until we change our entire scheme and rationale for the application of jurisdiction and law, it is unlikely to be the last. What you can do about this is to become aware of these issues and educate yourselves and your neighbors and come forward as birthright Americans. Join your state assembly and reopen all your courts, including the postal district courts, which are hanging on by a thread. Learn how to quickly and succinctly tell the British bounders who you are and where you stand and which law you stand under, and make it stick. Realize that your landlubber local postmasters are also public notaries, and your post office authority is key to restoring and exercising your authority over your land, and to redeeming control of and benefit from all the millions of acres of American land that have been subsumed as post road, railroad, and utility corridors and easements. So once again, I'm going to say it. What you can do about this, and what we can do about this, and what we need to do about this is to become aware of these issues, educate ourselves and our neighbors, come forward as birthright Americans, join our state assemblies, and reopen all our courts, including our postal district courts, which are hanging on by a thread. So that's what we're going to do, y'all, and we're going to do it together. So those are the misconception videos. I'm just going to keep this one nice and short. Like I said, I'm going to provide all the links at the bottom. And just to reiterate, there's the county national jurisdiction, which is the soil jurisdiction. And that's made of, the lowercase people, the people who live and breathe and populate their county. And all the counties in a nation state, so I'll use Georgia, for example, all 161 counties in Georgia make up Georgia's national jurisdiction. Now, when we're talking about Georgia, we're talking about Georgia's national jurisdiction, we're talking about the soil jurisdiction. Now, when we talk about Georgia dealing with the other states in international land jurisdiction, right, in international business, we're talking about the international land jurisdiction. So all the counties make up the union, right? That's the national jurisdiction of this country. That's uppercase, lowercase, the United States, because it's all the states united. And then the international jurisdiction, the land jurisdiction, is the uppercase, lowercase, the United States of America. And that makes up all the national jurisdictions connected. Remember, we're living people, obviously. We're actual, we're factual. We stand on the land and soil jurisdiction of our county or our state. We have no affiliation with the corporate state of state unless we, in some way, are employed by them. If we're in some form or another, providing some type of governmental service. And if we are, at that point, we're not people, we're persons. because we're acting in a capacity which is not lawful, which is legal. And we're acting under delegated authority. So the only time that we're subject to codes, policies, rules, regulations, procedures, mandates, orders, all those, is when we're acting in the legal person capacity. And or we're an employee for some type of governmental service provider. When we're one of the people, when we're a man or woman, we stand under the public law. We have our constitutional protections and guarantees. We have all our unalienable rights intact. And I'm actually going to read those unalienable rights to y'all. I'll just pull it up and read that to y'all. So unalienable rights. Unalienable rights are the inherent, sovereign, natural rights that existed long before the creation of the state, and which, being antecedent to and above the state, can never be taken away, diminished, altered, or leaned upon by the state, subject only to the due process of the common law. Nor can any unalienable right be fundamentally removed, whether mistakenly by contract through non-disclosure, which is fraud and unenforceable in law, or knowingly by renunciation, which is contrary to natural law. These are the original permanent unalienable rights of every man or woman. We have the right to life, freedom, health, and the pursuit of happiness. The right to contract or not to contract, which is unlimited. So if we're exercising any one of our rights, our governmental service providers try and apply codes, policies, rules, procedures, mandates, all those to us. It's up to us. We have the right to contract, or we have the right not to contract, and that's an unlimited right. We have the right to earn a living by being compensated with wages, a salary, or any trade goods in a fair exchange for one's work. That means work for pay. The right to travel in an ordinary course of one's life and business. So remember, we exercise our right to travel. We don't drive. We don't need licenses. We're men and women with unalienable rights. If we purchase property and we're using it for in a non-commercial way, or not for any for hire capacity, we're not working for Uber. We're not working for taxi service. We're not working for the state in some way as a law enforcement officer, or as a state patrolman, or as a we're not working as a post office worker or a FedEx driver. All these people are driving, and they're working. That's why they need a license to prove that they're in some way competent to do that role or that job. If we're just exercising our right to travel, that's exactly what we're doing. We're just exercising our right to travel from point A to point B as peaceful private Americans. And we know that if we cause injury or harm to another's property or rights, then there's consequences. Common sense. Common law for the common man or woman. We have the right to privacy and confidentiality, free from unwarranted invasion. So you see that, guys? We have the right to privacy and confidentiality. So if we haven't committed any harm, any injury, and someone's asking us for our private business and our private information, we have the right to privacy and confidentiality, free from unwarranted invasion. We have the right to control and hold one's property lawfully without trespass. We have the right to control and hold one's property lawfully without trespass. So what can my property be? It can be a car. It can be my body, right? It can be my thoughts, right? It can be my house, right? It can be my baby, my biological property, right? And I have the right to control and hold my property lawfully without trespass. We have the right to self-defense when threatened. with harm, loss, or deceit when it comes to our property. We have and remember, our rights are our property, our bodies are property, our life our property, our freedoms are property. Most things, if they really have anything to do with us, they're our property. The right to be presumed innocent. Oh, I missed one. The right to due process of law, with notice and opportunity to defend. The right to be presumed innocent, suffering no detention or arrest, no seizure or search without reasonable cause. Reasonable cause, by the way, is, injury or harm was caused to another's, rights or property, and in some way, with a wet ink signature, a warrant was signed, saying exactly the exact location, with the exact item, with the exact name of the owner. All that is reasonable cause, and that never happens and never exists. So the one that we mostly, when people say, I smell something, I got probable cause, that's all color of law, number one. And number two, remember, you have the right to control your own property. No one can tell you what you can and can't have as long as you're not harming anyone with it. We have the right to remain silent when accused to avoid self-incrimination. Now, because all these governmental service providers, because they're all, unlawful, because they're all legal constructs, because they only deal in the world of legal fiction, the only way to actually incriminate yourself, unless it's a real crime, is, by consent, by, admitting that you did something that they said was in some way wrong. We have the right to equality in the eyes of the law, right? We're all equal under the law. All people. All people. No matter if you're a woman, man, child, ethnicity, race, color, religion, creed, group, tribe, gang, whatever you want to say, right? We all have the right to equality in the eyes of the law and to equal representation. We all have the right to trial by jury, being an impartial panel of one's peers. We have the right to appeal in law against conviction or sentence, or both. We have the right to expose knowledge necessary to one's rights and freedoms. So if anyone's ever trying to trespass on our right, and they're trying to impose, certain codes, policies, rules, procedures, mandates, regulations, all those that don't apply to us, it's up to us, because we have the right to expose knowledge necessary to one's rights and freedoms. So it's up to us to either, explain what our rights are and stand on them, or explain that, those rules and regulations would apply to me if I was, acting in some type of capacity as a governmental service employee, but I'm not, or to say, actually the only contract I have with you is the Constitution, and, my Bill of Rights are laid out right here, and, your enumerated services are laid out right here, and, what you're doing right now, you're acting under color of law, because it has nothing to do with any of these enumerated services, and in no way are you protecting my constitutional rights and protections, my constitutional protections and guarantees. They're not constitutional rights. Remember, they're rights that we're born with. They're endowed by nature, and nature's God. The right to peaceful association, assembly, expression, and protest. It says peaceful. It doesn't say rioting. It doesn't say, belligerent. It says peaceful. Now, peaceful does include, your right to keep and bear arms. It does include your right to assemble in a group. It does include your right to ask important questions and pressing, to press for information. That is peaceful, and that is the law. That is your not only our duty, but it's our right. The right to practice a religion and to have beliefs of one's choosing. That's it. So as long as you're not harming another, causing trespass in any way, shape, or form on another, you can believe whatever you want. You can believe that, in this, you can believe that in behind closed doors, You can stand on all fours and walk like a dog and bark. Hey, if you're not harming me or trespassing on my rights, I got nothing to say against it. But the moment you try and videotape that and force every 2-year-old to watch that for 10 years of their lives, that in some ways causing harm or trespass. We have the right to love and to consensual marriage with children as a family. Same thing. So we have the right to love whoever we so choose. That's it. And they have the right to love us. We just can't project those beliefs on others in a way that's harmful. So the same way, we can't force a 5-year-old to, think that only one way is proper, or to think that, or whatever. You know what I'm saying. As long as you don't cause trespass or harm on another, you can do whatever you want. That's what rights are. Rights are unalienable, and everyone has them. So everyone has the same equal protections, equal guarantees, equal safeties. We have the right to security from abuse, persecution, tyranny, and war. We have the right to refuse to kill under command by reason of conscience. So even if we are doing a job and they're telling us that we have to do something, if it goes against our conscience, we have the right to refuse that kill, to kill under command. We have the right to live in peace and to be left alone when law-abiding. So, traveling from point A to point B without a license plate, for a man or woman, that is their right. A man or woman, they have the right to tape record conversations and, pressing debates and to hold both themselves accountable and others accountable, as long as they're law-abiding, as long as they're not causing harm or trespass in any way, shape, or form. So, these are our rights, and clearly if we all knew them, and once we all know them, and once we, start spreading them and start honoring them, life gets very easy for both us and for others around us. So surely the most critical failure of the people is their failure to ensure the teaching and common knowledge of their unalienable rights. If you do not know your rights, you effectively have none by the path of ignorance, whether by apathy, by choice, right, or deception. The people arrive in a state of exploitation, oppression, and tyranny. So again, how do we fix that? Well, what we can do about it is to become aware of these issues, right? To become aware of these rights, to become aware of these structures, right? And these relationships and these jurisdictions and the proper way and how they're supposed to be. To become aware of our proper capacities, right? We're lawful persons. We're people with a capital P, right? We're the ones that, if we so choose, obviously. Not if we're, a governmental service provider. Then we're not. Then we're a legal person. But what we can do about this is to become aware, like I said, of these issues, to educate ourselves and our neighbors, and to come forth as birthright Americans, to join our state assemblies, and to reopen all our courts, our own courts, including the postal district courts, which are hanging on by a thread. We can learn how to quickly and succinctly tell these British bounders who we are and who they are, where we stand and where they stand, and which laws we stand under and which don't apply to us. So again, thank y'all for checking in. See y'all at the next video. The next one, like I said, is going to be all about state assemblies. So much love, y'all, and appreciate y'all checking in. Appreciate y'all doing research and, jumping in, because that's the first step towards self-governance. Beyond that, it just takes, like I said, just like you learning a song. You just keep applying this information, or keep subjecting yourself to situations or conversations. Using the proper verbiage. With your state assembly, with your neighbors. Like I said, read these contracts. Definitely read these links. So shout out, y'all. And I'll see you on the next video. Goodbye from a lawful Georgian, standing on the American land and soil of Georgia. It feels good to be here, and I can't wait to see y'all.